Hi, everyone. This is Mike. This is part 5 of the podcast on the Fourth Amendment. In this episode, I'm going to talk about evidentiary search and seizure. Like arrests, searches and seizures have to be reasonable in order to be valid under the Fourth Amendment. The issue here turns on what is reasonableness. What is reasonable? Reasonableness usually means that the police have obtained a warrant before conducting a search. However, there are circumstances where a warrant is not required, and yet the search and seizure is still considered to be reasonable. These are what we refer to as exceptions to the warrant requirement. A useful approach for backing our way into a search and seizure question to determine whether A, there was a Fourth Amendment right that was implicated, and B, whether the police followed proper protocol and obtained a warrant or relied appropriately upon one of the exceptions, is by examining this through the prism of 3 questions. And the first question actually has 2 subparts. But we begin by asking, does the defendant have a Fourth Amendment right? And the sub-issues here are, was there governmental conduct? Essentially, was there a law enforcement officer involved in the search? Or it could even be a citizen that was acting at the direction or behest of a law enforcement officer. We'll get to that in a second. The second sub-issue is, did the defendant have a reasonable expectation of privacy? Now, keep in mind here that these are all legal terms of art that the courts use, and so every word has a meaning that is different than the ordinary everyday meaning of the word. So it's important for us to actually define what these phrases mean and their relevance to the big picture issue. The second big question here in our approach is, if the defendant had a Fourth Amendment right, did the police have a valid warrant? Again, every word here has meaning. Valid means that the affidavit that the officer relied upon in requesting the issuance of the warrant has to have contained probable cause. So there are hearings, even when a warrant is involved, where the judge is called upon to decide whether the affidavit contains sufficient probable cause for the issuing judge to have issued the warrant. The third key issue is, if the police did not have a valid warrant, did they nonetheless make a valid search, a warrantless search and seizure? And here, what we're really getting at is whether the search and seizure falls within one of the recognized exceptions to the warrant requirement. Let's delve into the requirement of governmental conduct. Now, the Fourth Amendment generally protects only against governmental conduct and not against searches by private persons. So the issue here is, who is a governmental agent? Well, we don't have to look too far to recognize who they are. They're local police, enforcement officials, they're police officers, they're detectives, they are, if they're on the federal side, they're FBI special agents. However, as I alluded to a little while ago, they could also, government agents could also be private citizens that are acting at the direction or behest of law enforcement. So a quick and dirty example could be a case where a landlord finds some drugs on a dresser or on a desk in the apartment when he's doing a routine inspection or when he has let in a plumber. The landlord then contacts the police. The police come to the location and they order or give directions or instructions to the landlord to lift or to examine the packet that contains the suspected cocaine. Well, if the landlord, even though he is a private actor, is acting at the direction or behest of law enforcement, that is considered to be governmental conduct, notwithstanding the fact that the landlord is not a police officer. Now, how about private security guards? How about loss prevention officers? These have become more routine and common cases, especially when there are issues involving shoplifting and things of that nature. Well, private security guards are not government agents unless they're deputized as officers of the public police. And so, as you can imagine, this triggers a number of issues, especially in the case where a loss prevention officer stops somebody from leaving, say, a Target or a Walmart and detains that person in a back room while notifying the police that there was some suspected shoplifting. And if that loss prevention officer then takes it upon him or herself to search or asks for permission to search the shopper's personal belongings, we get into this whole issue of, was there governmental conduct involved? And we'll discuss that a little later. But here's a quick and dirty example to help drive this concept home of government conduct required. In this case, a private freight carrier opened a package and resealed it. Well, lo and behold, they found what they believed to be a packet of cocaine inside that package. They notified the police, and the police arrived shortly thereafter. They reopened the package. The Supreme Court found that this was not a search under the Fourth Amendment. Why? Well, they reasoned that the police found nothing more than what the private freight carrier had found, this bag of cocaine. Moreover, the fact that the police went one step beyond what the private freight carrier did by actually conducting a field test of the substance found in the package to determine whether it was cocaine or not, still did not rise to the level of a Fourth Amendment seizure. So the police went beyond the scope of the original private search by conducting a field test of the substance, but nonetheless, the court found that it was still not a Fourth Amendment seizure. And that comes out of the case of U.S. versus Jacobson, decided back in '84. Now we move on to this issue of reasonable expectation of privacy. So what must a person have to have a Fourth Amendment right? Well, it's kind of a redundant question. The person must have a reasonable expectation of privacy with respect to the place searched or the item seized. Now, it's not enough merely that someone has an expectation of privacy in the place searched or the item seized. The Supreme Court has imposed a standing requirement so that a person can complain about a search or seizure only if it violates his own reasonable expectation of privacy. Whether a person has a legitimate expectation of privacy is based on the totality of the circumstances. However, the court has provided us with some factors that we can use to review whether there was a legitimate expectation of privacy in the place searched or the item seized. And one of the factors is the ownership of the place searched. Another factor is the location of the item seized. The other thing that the court has provided is that situations where a person has a legitimate expectation of privacy anytime. And there are a total of 3 of those. The first is when the person owned or had a right to possession of the place searched. The second is when the place search was actually the person's home, whether or not the person owned or had a right to possession of it. And the third situation where a person has a legitimate expectation of privacy anytime is when the person was an overnight guest of the owner of the place searched. Part and parcel of this issue, and by the way, this is sometimes referred to as the standing issue. An issue that comes up frequently when it comes to standing is searches of third-party premises. So standing doesn't exist merely because a person will be harmed by introduction of evidence seized during an illegal search of a third person's property. And here's an example to help drive home that concept. The police officer peers through a closed window blind of a lessee's apartment and observes the lessee and defendants bagging cocaine. When the defendants leave the apartment, the officer follows them surreptitiously to their car and arrests them. The officer searches the car and the apartment and, lo and behold, finds cocaine and a weapon. At trial, the defendants moved to suppress all the evidence, meaning to withhold it from the eyes of the jury so that it never becomes part of evidence in the trial. Essentially, when it comes to possessory offenses like those involving drugs and weapons, if a defendant wins his or her suppression hearing, the case is all but dismissed because without the evidence, of course, the prosecutor cannot prove the possessory offense of possession of a controlled dangerous substance or unlawful possession of a weapon. So, again, the defendants raise this issue of make a motion for a suppression hearing to suppress the cocaine and the weapon, claiming that the officer's act of peeking through the window blind constituted an illegal search. The facts that were later determined were that the defendants had spent little time in the lessee's apartment and had come there solely to conduct a business transaction, namely the bagging of the cocaine. The court here held that the defendants did not have a sufficient expectation of privacy in the apartment. The court reasoned that they were there only for a few hours and were not overnight guests. Moreover, they were there for business purposes rather than social purposes, and there is a lesser expectation of privacy when it comes to a business or commercial setting. Therefore, the court held that the defendants had no Fourth Amendment protections in the apartment and that they could not challenge the search. Now, in the state of New Jersey, we have something called automatic standing to object to the legality of a search and seizure anytime the evidence obtained is possessory and that is being introduced is a possessory offense. So anytime a defendant is charged with a drug offense or a offense involving a weapon, it could be unlawful possession of a weapon for not having a gun permit and yet carrying a weapon. Anytime a defendant is charged with a drug-related offense or a weapon-related offense, the defendant has automatic standing. What that means is that he has it's automatically assumed that there's a legitimate expectation of privacy without the defendant having to admit during the hearing that that unlawful item was his. So you can see the contradiction here. If the reverse were true, meaning that the defendant had to claim ownership of the gun or the drugs in order to satisfy the first hurdle of standing, then no defendant would do such a thing, because that would be basically giving the case away, since the whole crux of a possessory offense is proving that the item belonged to the defendant. So there would be no suppression motions, because no defense attorney worth his salt would encourage a defendant to admit to ownership of the drugs or the gun just for the purposes of the hearing. Because if the hearing is lost, meaning that the judge denies a motion to suppress, God forbid the statement made by the defendant at the time of the hearing could later be used against him or her at the trial. So to avoid all of that drama, what courts have held in New Jersey is that a person has automatic standing to object to the legality of a search and seizure anytime the evidence obtained is being introduced against her in a possessory offense. Now, I want to get into this topic of things held out to the public, because this is a very gray area where not everything enjoys an expectation of privacy. So a person does not have a reasonable expectation of privacy in objects held out to the public. And so that's a bright line rule that the Supreme Court established a long time ago. What type of objects might have the characteristics of being held out to the public? Well, the sound of one's voice, one's handwriting, paint on the outside of a car, the smell of one's luggage or car. Now, when we talk about the smell of one's luggage or car, we're talking here about drug sniffs by narcotics dogs, canines. Account records held by the bank. A car's movement on public roads and arrival at a private residence, even if detection of that movement requires the use of an electronic beeper placed on the car by the police. Magazines offered for sale. So all that laundry list does not enjoy an expectation of privacy, because it's considered by the court to be held out to the public. Now, in comparison, luggage has posed a challenge to the Supreme Court, and the Supreme Court accepted or granted cert on a case involving the squeezing of some luggage. Although the Supreme Court has held that one doesn't have a reasonable expectation of privacy in the smell of one's luggage, the Supreme Court has held that one does have a reasonable expectation of privacy in luggage against physically invasive inspections. So they're using, very technical language here, but for all intents and purposes, what we're talking about is squeezing luggage. Squeezing luggage to determine what is inside constitutes a search. Okay, so a good example here is a case that was decided a while back. It's the case of Bond versus United States. And in that case, after completing an immigration status check of passengers on a bus, the officer began walking toward the front of the bus and squeezing soft-sided luggage in the overhead compartment. So I'm sure the visual here is very colorful here. You have an officer who is on a bus He was walking towards the front of it, and as he's walking towards the front of it, he's squeezing this luggage that's in the overhead compartment. Well, he feels what to him feels like a brick in one of the bags. And upon feeling that quote unquote brick, he immediately takes the bag down and searches the bag. Lo and behold, he finds a brick of methamphetamine inside. The court held that while travelers might expect their luggage to be lightly touched or moved from time to time, they do not expect their luggage to be subjected to an exploratory squeeze. Therefore, the officer's conduct constituted a search under the Fourth Amendment. Now, how about dog sniffs at traffic stops? Well, as long as the police have lawfully stopped a car and they don't extend the stop beyond the time necessary to issue a ticket and conduct ordinary inquiries incident to a stop, a dog sniff does not implicate the Fourth Amendment. So the key elements here is that there's a lawful stop of a car and the police do not extend the stop beyond the time necessary to issue the ticket and conduct ordinary inquiries. And so, there's no time limit. The court doesn't say, 1 hour is too long, but 20 minutes is okay. They always talk about it in very vague terms. But I would go so far as to say if we are talking about hours on where the driver is has been stopped and has been ordered out of the car, and the inquiries are coming fast and furious, and additional law enforcement officials arrive at the scene, and and this person now has been rotting on the side of the road for longer than an hour. I would say that that we're now getting into a very dangerous area where there is a prolonged stop and where the time necessary to issue a ticket and conduct ordinary inquiries incident to the stop has long since passed. But if the stop of the car, if the car is lawfully stopped and the stop is, it has not taken that long, and and it doesn't go so far beyond the time necessary to issue the ticket, conduct the inquiries, and the canine arrives swiftly, then it doesn't implicate the Fourth Amendment. So there is a case here where the court, and this is the Bond case, where the court held that the Fourth Amendment was not violated when there was a routine traffic stop. The police officer walked a canine around the defendant's car, and the dog alerted to the presence of drugs. Even though before the dog alerted, the officer did not have a reasonable and articulable suspicion that would justify the search. So, notwithstanding, the court held that the sniff was not a search. Now for the open fields doctrine. This is just a fancy way of saying that we're now talking about areas outside the curtilage. By curtilage, we're talking about the dwelling house and outbuildings. So whenever you hear the term open fields doctrine, it refers to areas outside of the dwelling house and outbuildings. Areas outside the curtilage are subject to police entry and search. These areas are held out to the public and are unprotected by the Fourth Amendment. What are some of the factors that the court will consider when determining whether we are dealing with areas outside the curtilage? Well, they'll consider the building's proximity to the dwelling, whether it's within the same enclosure, like a fence that surrounds the house, whether the building is used for activities of the home, and the steps that are taken by the residents to protect the building from the view of passersby. Now, even a building like a barn may be considered to be outside the curtilage and therefore outside the protection of the Fourth Amendment. In addition, the Fourth Amendment does not prohibit the warrantless search and seizure of garbage left for collection outside the curtilage of a home. So there is no reasonable expectation of privacy in garbage that has been that's left out for collection on the curb. How about flyovers? This is a fascinating area that there's been a lot of case law on over the last 20 years or so. It began with this case of California versus Serralo in 1986. In that case, the court held that the police may fly over a field to observe with the naked eye things in the field, and even a low flyover by a helicopter to view inside a partially covered greenhouse was deemed permissible. That was a case called Florida versus Riley, and it was a plurality decision based on the flight being permissible under FAA regulations. The police may also take aerial photographs of a particular site. Now, in comparison, we have this issue of technologically enhanced searches of homes. And what I'm referring to here specifically is the use of thermal imagers on a defendant's home. The Supreme Court held that due to the strong expectation of privacy within one's home, obtaining by sense-enhancing technology, such as a thermal imager, information regarding the inside of a home that could not have been obtained without physically intruding into the home constitutes a search, at least where the technology in question is not in general public use. This is the case of Kylo versus United States, decided in 2001. Law enforcement rather used a thermal imager on defendant's home from outside the curtilage, and what it detected was the presence of high intensity lamps. And essentially, high intensity lamps are commonly used to grow marijuana. So that, of course, aroused suspicion on behalf of law enforcement that the owner of the property was growing marijuana plants inside. And again, here, the court held that the use of this thermal imager on the defendant's home from outside the curtilage to detect the high-intensity lamps constituted a search. Now, keep in mind here that the issue was whether it was a search, whether the use of the thermal imager was a search. We haven't gotten to the issue of whether it was lawful or not. So the issue is still one of, is it a search? And again, the court held that that using by sense-enhancing technology, that obtaining rather by sense-enhancing technology information from about the inside of a home that could not have been obtained without entering the home constitutes a search. And in Kylo, the use of that thermal imager did rise to the level of a search. A police officer can also constitutionally reach into a car to remove papers to observe the car's vehicle identification number. That was a case decided back in 1986 called New York versus Class. So we're going to end here and pick up with searches conducted pursuant to a warrant in the next episode.